Establishing a hedge fund in the BVI. The BVI benefits from a diverse offering of hedge fund products suited to everyone from the startup manager setting up an incubator fund to established institutional fund managers with billions under management. Its pragmatic flexibility over the 25 years of prudent regulation has actually been a large driver for the popularity it has generated amongst the global investment funds community. The characteristics of the products available are set out below. If you need help choosing the most suitable product for your fund, please contact us. Incubator Fund. The incubator fund is aimed at emerging managers and allows them a 2-year incubation or validity period, with an extension of up to 12 months available with permission from the Commission, to establish a track record and test its viability. During that period, the fund can operate with light regulation, very limited mandatory service providers, and without having to carry out an audit. An incubator fund must remain within the following thresholds. Having no more than 20 investors. Each investor, having been invited to invest, must make a minimum initial investment of $20,000. The net assets of an incubator fund must not at any time exceed $20 million. Before the end of the validity period, or, if earlier, when it exceeds the relevant thresholds for 2 consecutive months, an incubator fund is required to convert to a private, professional or approved fund. If the fund determines that it is not viable to continue, it is required to wind up its operations. The incubator fund is required to conduct an audit as part of its conversion to a private or professional fund. An incubator fund benefits from a fast-track approval process, enabling it to commence business as an incubator fund 2 business days after submitting a complete application to the Commission. Approved Fund. The approved fund is aimed at managers looking to establish a fund with a private offering to a small group of investors on a longer-term basis. An approved fund is restricted to having no more than 20 investors. Having net assets which do not at any time exceed $100 million. The approved fund has similar characteristics to the private fund recognized under SIBA, including no minimum initial investment for investors. Unlike the private fund, the approved fund is not required to appoint an auditor. It is also not required to appoint a manager or a custodian, unless it is set up as an SPC. Please see below for more details. It is required to appoint an administrator to ensure there is some suitable oversight of its operations. Like the incubator fund, the approved fund benefits from the fast-track approval process, enabling it to commence business as an approved fund 2 business days after submitting a complete application to the Commission. Private Fund. Private funds do not have a minimum initial investment amount for each investor or any professional or sophistication test for investors. This has made them popular with startup managers, allowing a friends and family offering. A private fund is restricted to either having no more than 50 investors, or only making an invitation to subscribe for or purchase fund interests on a private basis. Private funds must be recognized by the Commission before they carry on business. Historical policy guidelines issued by the Commission under the previous mutual funds regime suggested that a fund will be regarded as having commenced its business when a prospectus, or other document the purpose of which is to make an invitation to purchase or subscribe for shares of the fund, is published. Professional Fund. Professional funds are the most popular category of regulated fund and make up approximately 65% of all regulated funds in the BVI. The interests in a professional fund may only be made available to professional investors, and the minimum initial investment by each professional investor must not be less than $100,000 or other currency equivalent, unless the investor is an exempted investor, in which case there is no minimum initial investment. A professional investor is a person whose ordinary business involves, whether for that person's own account or the account of others, the acquisition or disposal of property of the same kind as the property, or a substantial part of the property, of the fund, or who, whether individually or jointly with their spouse, has a net worth in excess of $1 million, or other currency equivalent, which does include the primary residence. An exempted investor means the manager, administrator, promoter or underwriter of the fund, or any employee of the manager of the fund. A professional fund may carry on its business or manage or administer its affairs for a period of up to 21 days without being recognized under SIBA. Public fund. A public fund is generally viewed as a retail product. Accordingly, the regulatory burden placed on a public fund is considerably higher than that of a private or professional fund. Public funds must be registered by the Commission before they carry on business. A public fund is not subject to any BVI restrictions on the categories or number of investors it may invite to invest in the fund. Registered public funds may not make an invitation to the public or any section of the public to purchase shares unless prior to such invitation they publish a prospectus which complies with SIBA and the Public Funds Code, which is approved by and signed on behalf of the fund's directors and which is registered by the Commission. Investment funds in the BVI are subject to various ongoing statutory requirements under SIBA and other secondary legislation. Incubator and approved funds are subject to lighter regulatory requirements, whereas the burden is higher for public funds. Please contact us for our separate guides on continuing obligations for all of these types of funds. The vast majority of BVI hedge funds are established as companies limited by shares under the BVI Business Companies Act 2004, BCA, and we would generally recommend using this structure. Limited partnerships are also quite common. Although permitted, we rarely see unit trusts, but we would of course be happy to discuss them with you. BVI Business Companies. A BVI business company is a separate legal entity from its investing shareholders, whose liability is limited by statute. The shareholders of a BVI business company have no direct legal or beneficial interest in any of the assets of the company, which are instead legally and beneficially owned by the company itself. The BCA is very flexible for structuring funds. For example, there is no concept of authorized capital or share capital under BVI law, and shares do not need to have any par value or capital attributed to them. The directors may also designate different series of shares within each class of shares without the need to amend the constitutional documents of the fund, giving flexibility to funds wishing to use series accounting techniques to achieve equalization of performance fee allocations among shareholders. The BCA also allows private, professional, public, incubator and approved funds to be structured as SPCs. An SPC is a single company with the benefit of statutory segregation of assets and liabilities between segregated portfolios established within the company. The assets and liabilities of each segregated portfolio are legally segregated from both the assets and liabilities of each other segregated portfolio and the general assets of the company, i.e., those assets not held within one or on behalf of any segregated portfolio. SPCs are popular for multi-class or umbrella funds in which two or more segregated portfolios use different investment strategies. Limited partnerships. A BVI limited partnership is formed by a general partner and at least one limited partner executing a limited partnership agreement, or adopting a statutory model form agreement, and the registered agent submitting a registration statement and registered agent consent to act to the BVI Registrar of Limited Partnerships. The partnership agreement forms the internal governing document of the limited partnership, dealing with issues such as partnership contributions and withdrawals and the day-to-day running of the limited partnership, and does not have to be filed with the BVI registrar. A BVI limited partnership can elect whether to have a separate legal personality distinct from its partners. The general partner of a BVI limited partnership is ultimately liable for the debts and obligations relating to the limited partnership. As a matter of BVI law, a limited partner BVI limited partnership is not liable for the debts and obligations of the limited partnership, save for the amount contributed and any unpaid commitment. The general partner of a BVI limited partnership is typically a company or LLC and does not need to be a BVI entity. There is no requirement for the general partner to appoint a BVI resident director or for the directors to register with the Commission.